Good morning and welcome to our next live. My name is Adam Gauthier and today we will be talking about loans in Polish Zloty, and more specifically we are going to be talking about the interest rate called WIBOR. I would like to welcome Nina Seman, who is
Hello everyone. Good morning.
Who is attorney at law at my law firm, who helps me to deal with the cases concerning loans, not only in Polish zloty but also in
francs.
But not only, also in euros. Recently, we got another verdict stating that a loan contract was not valid, and therefore the bank is forced to pay back all the money that our client has given to the bank. So let's talk about the WIBOR.
WIBOR. So could you explain what is WIBOR? How does it work?
So WIBOR stands for Warsaw Interbank Offered Rate. In simple terms, it is the interest rate on the interbank market at which banks agree to lend to each other. It is therefore an indicator of the amount at which a bank borrows money in the financial market in order to put it into circulation and lend it further to the customers. It is intended to compensate banks for the cost of raising funds made available to customers in the form of loan or credit. The WIBOR reference rate is determined as the arithmetic average of interest rates from information provided by the 10 biggest banks. The WIBOR rate, which is administered by WSE benchmark, is determined on the basis of transactions between those banks that lend money to each other. And it has to be emphasized that it is a floating index determined almost daily, which has a significant impact on every credit.
Okay. And what are the borrowing costs made up of the WIBOR reference rate?
The WIBOR reference rate is part of the interest rate on your loan, which in addition to WIBOR also consists of a fixed margin for the bank as its remuneration. In loan agreements, you may encounter different variants of WIBOR, such as 1M, 3M, 6M, or 12M, and the symbol is an indication of how many months the WIBOR will be updated in relation to your loan installment, and therefore how often the interest rate and consequently the amount of your installment will change.
Okay. And could you explain why are Zloty loans contracts with WIBOR rates flawed?
Actually, there are two reasons that those contracts might be claimed as flawed. Firstly, this is due to the flawed way in which the contractual interest rate is determined based on the WIBOR reference rate. Currently, the WIBOR rate is not based on the actual costs that banks incur to raise funds. The WIBOR refers to the costs bank would incur if they borrowed funds from each other. So it's just a hypothetical situation. It's not a factual cost that banks make. The WIBOR refers therefore to the costs that bank would incur if they borrowed funds from each other. And meanwhile, in reality, banks' lending is based not on the interbank loans, but on deposits, and the interest rate of which is much lower than the interest rate on a loan. So the costs of the bank incur in order to raise money for the customers are actually lower than the banks declare. And the WIBOR reference rate does not, in fact, reflect the real cost of raising capital by the bank and is significantly inflated relative to such a cost, and is not an afterthought for the transactions made by the bank, but they result only from the declarations made by financial institutions. And such excess becomes an additional cost of credit that the bank receives from the customer. And it is therefore a hidden cost on one side that appears in terms of recalculation of the installment. So this is one reason why this clause must be flawed and therefore invalid. There is also another reason. The effectiveness of such contracts is also due to the fact that banks usually do not properly inform the customer, which is consumer, of the economic consequences associated with the interest rate changes and the actual scale of the unlimited risk associated with the variable interest rate, as well as the lack of information on what WIBOR is and how exactly, specifically, it affects the loan. Contracts are supposed to be transparent, and they should allow borrowers to verify, to be able to check during the contract the amount of the loan installment and the interest rate charged by the bank. The agreement cannot give the bank complete freedom to set the interest rate by stating that a change in the interest rate may take place in the event of change in the reference rate. Consequently, the bank should adequately and comprehensively warn the customer of the risk that paying installments will become unaffordable in the event of a strong interest rate increase. And based on the above mentioned circumstances, it can be concluded that contracts for Polish zloty loans with interest rates based on the WIBOR reference rate may contain prohibited contractual provisions.
Okay, thank you for this explanation. And as a customer, if I sign this kind of contract with the WIBOR rate, what can I do?
We encourage to do the analysis of such loan agreement in order to assess whether they are defective and whether the provisions concerning the WIBOR reference rate may be challenged. Each case should be assessed individually. So an analysis of a specific agreement will allow to clearly determine whether the agreement has been structured in a defective manner or whether it contains prohibited provisions, and then we will be able also to determine what action, if any, we can take against the bank. And also it is worth mentioning that like in the cases of the CHF loans contracts, there were supposed to be, we were supposed to have a general solution to the problem, but then in fact, in each specific case, it should be judged by the court and stated that the specific contract is not valid and therefore never existed to receive all the benefits of this statement.
And could there be any negative consequences by taking action against the banks?
So banks cannot sanction, penalize, or punish customers who assert their rights, who make claims in order to restore the balance between the parties so that the mutual benefits are equivalent on both sides and not only on the side of the customer to compensate for the increases. So according to the jurisprudence, as well as the position of the European Union institutions, banks cannot draw negative consequences, for example, by giving notice of termination against customers who take this type of action. There are no grounds for this type of behavior on the part of financial institutions.
Okay, thank you very much for the explanation of this this topic, which is really
very hot nowadays.
Yeah, exactly.
So we receive many questions concerning those loans. So next week on the same time, 9 a.m., we will continue to talk about this topic. We will present the calculations of a contract of the interest rate and on how much of the interest rate WIBOR contains, and we will take as an example one of our clients' contract. We will also talk about the newest judgments on the case. There has not yet been a definite decision on the matter, but we have certainly already received some of the decisions taken due to the safeguard procedure. So we will present what the court in Katowice has decided, what the court in Warsaw has decided on the matter. So we are more than pleased to invite you to our next live next Wednesday.
So thank you very much for listening.
Thank you very much for your attention. Have a nice day. Bye.
Bye.